Good evening, everybody. My name is Purnima Hakti, and I head the dispute resolution team at Samvad Partners. It's my pleasure to host today the first joint webinar that Samvad is having with CAMP, the Center for Arbitration and Mediation Practice here in Bangalore. It's my privilege to have Tara Olapalli, who's the Executive Director at CAMP, with us. Before we proceed with the webinar itself, if there are any technical issues and you can't hear us, please send us a message. I think the software allows you to do that. If you have any questions, we'd be happy to take them as and when we progress. We will also take questions right at the very end. This webinar is being conducted like a conversation, both from the practitioner's point of view as well as a stakeholder who's involved in making mediation a way of life in India. And that's Tara who will be giving that perspective. We will be looking at mediation primarily from a perspective of commercial mediation, which is where Samvad's strength really is in commercial mediation. I think a large part of the audience is also interested in commercial mediation. Of course, we will take questions on any other areas if that's interesting. We'll start now, as I said, if there are any technical issues, please feel free. You should be able to see the slides before you, and we'll keep looking at the slides and guide you through the slides as well. Here we go. So today we're going to be talking about commercial mediation in India in the context of the changing face of dispute resolution. Whether mediation is becoming a better way of life, or how do we look at it? We will look at specific legislations in this context, both changes that have been made to existing legislations in terms of helping dispute resolution. And finally, we'll look to see, after looking at some statistics, we'll also look at sort of some interesting developments at the international stage to help show you how commercial mediation is becoming more interesting. Tara, would you like to introduce CAMP a little more before we go in detail?
Yeah, thank you, Purnima, for putting this together. It's my privilege to speak to all of you about private commercial mediation, to speak to you about CAMP. We are a private mediation institution that is looking to provide access to high quality mediation, especially in the commercial field. Our founders, our team, include mediators who were part of the setting up of the Court Annex mediation program, and now it is our focus to be able to get commercial parties be able to use mediation more effectively. And through the course of the next hour, we'll be able to share with you what it's looking like in other jurisdictions, how international companies are using mediation more and more, and make the case for why that is the next big thing here in India too.
So if you now look at the slide before you, what is really the changing face of dispute resolution, and where is mediation in that? Legislation that now formally include mediation to resolve disputes, cross-border mediation, and looking forward to the Singapore Convention, which we'll talk a little bit more in detail once we get towards the end of the presentation. If you now look at the third slide, it's no secret that courts in India continue to be clogged. So the effort really is to look beyond the court system, while there are efforts to make sure that we have increased number of judges and court case management rules are being enforced. The idea really is, if we have to resolve the crisis that is the Indian litigation system, we have to look to ADR. And when we say ADR, all aspects of ADR are being strengthened, and different focus areas continue to exist, both from Lok Adalats to arbitration, and then mediation. Mediation has been a key focus, whereas arbitration has had a push for a much longer time. In the past 5 to 10 years, mediation has had an increased focus, both from the government as well as private stakeholders. There has been an increase in private mediation, and we'll discuss why that has happened. The amendments to the CPC, as most of you already know, Section 89 and subsequently Justice Ravindran's judgment of AFCONS that came from the Supreme Court elucidating 89, which did have a little bit of debate on whether there is something like compulsory mediation. Can you ask parties to go off and mediate through an order of the court when it is really a voluntary process? Was discussed quite a bit. And people have said, look, it's got its benefits if you have to go off and mediate. It continues to be a voluntary process, and you can come back and report that. That was a huge change in the Civil Procedure Code, along with changes in Order 10, as set out in the slide, Rules 1A, 1B, and 1C, facilitate this process and tell you how to go about it. But as has been much talked about, there is a need for easing up of the doing business in India. The World Bank has said that we're better, but to some extent because of the changes in the Insolvency and Bankruptcy Code, and changes in the Companies Act, and the introduction of the Commercial Courts Act that has happened across the country. But actually, in terms of practicing lawyers' perspectives, we are not seeing that much in terms of a quick turnaround of disputes, quick resolution of disputes through the formal court system. Which then means that we really have to look towards, alternate dispute resolution in the context of this presentation, really mediation. Farah?
And to add to that, speaking to the changing face of dispute resolution from a mediation standpoint, I've been in this game now for the past 4 years, and I know that the kinds of cases that are coming into mediation are changing. So whilst at first it was probably largely matrimonial disputes or small claim disputes, today we are seeing commercial disputes coming in for mediation. Whether you're talking about IP disputes, partnership disputes, vendor disputes, we're seeing bigger value cases coming in for mediation. And there is no doubt in my mind that our dispute resolution landscape is going to take mediation more seriously. Also, in the way I see lawyers practicing law, I think there's been a change in the way dispute resolvers are practicing. The posturing, the hard-hitting litigator, we're seeing slowly becoming the collaborative dispute resolver. And so I see that as a huge change in the face of dispute resolution in India. When some of my Singaporean friends, said a pure litigator is a dinosaur. 5 years ago, we all laughed. But today, I think there's a lot of truth in what he said. And increasingly, as Purnima would affirm, dispute resolver or a litigation lawyer that she is using these collaborative dispute resolution processes more and more in your practice.
That's absolutely right, Sarah, because, a corporate client is not really interested, neither is the individual client, really looking to litigate in terms of going forward and continue to be with the court system for a number of years. And so the average timeline for a mediation, really, in terms of what we've done, it really is something between 12 to 14 hours and not beyond that. And of course, and it will, with a good mediator, you can actually say whether you settle that or not within that time period.
Yeah, and I think we'll have the opportunity to discuss that a little bit more in terms of how all of that is playing out practically. I think we to give a backdrop of where mediation is also from a global perspective. This is data that comes out of the United States. A survey was done by Cornell University tracking the use of different dispute resolution processes, first in 1997, then again in 2011. This slide shows the increased use of mediation from 97 to 2011 across various sectors, across various subject matters in dispute. This data also tracked the usage of arbitration versus mediation. And it was very interesting to see that from 97 to 2011, there was an increased use of mediation under these heads of commercial contracts, consumer IP, finance issues. there was an increased use of mediation and actually a dip in the use of arbitration. And why? Why is that happening, especially for commercial disputes? Essentially, the reasons quoted: time, cost, and then the kind of resolutions that parties find in these kind of processes. You're talking about business-friendly solutions that are coming out of creative, gathering a lot of information from a negotiation process that is interest-based, where the mediation process allows a lot more information, a lot more communication to be brought to the table, as a result of which there's an expansion of the dispute per se, allowing more creative options to come out of it. So these are far more business-friendly ways to be able to resolve a dispute, which is why you see statistics along the lines in front of you with respect to how parties are using mediation and how these processes are becoming more and more popular compared to the other dispute resolution processes out there.
Thank you. So moving on to the next slide, this is an increased focus on mediation. Almost every high court in the country now has a court-annexed mediation program. We have one which is running fairly successfully in Bangalore. I have personally appeared with the one in Bombay and have some knowledge of that the Delhi one is doing very well as well.
Yeah.
So there is a push from the high courts to make sure that mediation is part of the formal systems. And if you look them up on the internet, they are quite well known and well regarded. The growth in private mediation has primarily been because we have experts who come in and can facilitate mediation in the same private dispute resolution mechanism that exists for arbitration. Tara, on the public-private partnerships on mediation, what has been the camp experience?
Yeah, so private mediation, because there's a push for commercial mediation also coming into dispute. So we're seeing the growth of private mediation, and that's not just here, that's everywhere. Interestingly, private institutions like us are also trying to work with the court system. As you mentioned, we're a completely overburdened court system, 30 million cases that are pending in our courts. So we have actually worked at the consumer court. We have been in a public-private partnership with the consumer court, where our mediators afford pro bono services to the consumer courts. And it is a fine example of public leadership in bringing in various forms to reduce the workload or the caseload that they have. So we've been working with the courts, we've been working with on the amendments to the commercial courts and how the laws could be framed. A lot of mediators are working with our states and being able to be working with our government to be able to come up with better laws. Of course, you know, the Ministry of Law and Justice probably a year or two ago came up with an official circular urging government departments when in dispute to be able to use mediations. They've cited or they've identified institutions which are largely private institutions, as of course the court-annexed mediation programs as well that they could use. But basically there has been that push where if there is a government dispute, use mediation, whether you're talking about private forums, private mediation institutions, or public institutions to be able to use the process. So CAMP, along with a bunch of other private institutions, have been named by the government so that the government departments, when in dispute, could access mediation.
And this circular requires the government to do so for various dispute resolution forums.
Yeah, it's not a requirement, it's an urging. It is it's a recognition that there are over nearly 50% of our disputes involve the government, and so maybe even more. So to be able to urge government departments to use alternate processes to find quick resolutions, and therefore have been promoting mediation, whether it's the private or the court-annexed programs to settle these disputes.
Interesting. While that is still something that we continue to look at, the next slide will give you some statistics of the Bangalore Mediation Center. If you zoom in, apologies that it's a little bit quite distant. Now, this is the data period is from 1st of January 2007 to 28th February 2017. So it's a fairly extended period of time. And you'll see that in this time, the total number of cases referred for mediation was something like 56,759 cases. So that's a large number. Now, from our understanding and discussions with the Bangalore Mediation Center, we understand that a fair number of these were matrimonial cases. Yeah. But if you see, the first set is that some of these were not mediated and returned to court, and the reasons are set out there. 1% were considered not fit for mediation. Now, while obviously there are a class of cases such as criminal law, where there are rights in rem, which continue to be cases which cannot be mediated. So probably that's where these come from. Yeah. And then there were parties who did not turn up, and we've had that experience where we've tried to urge our clients to go to mediation. We've not had a responsive counterparty, so we've had to come back to court saying, the mediation failed. So that's about 8% where parties did not come, and we have another where both parties did not come, and about 7% where one party didn't come. So about 18% were not mediated. So that's not necessarily a failure of mediation, but for whatever reason they didn't actually go to mediation. And of the cases that were mediated, you can see the success rate is about 65% for Bangalore. And then those not settled is 35%. Now, bear in mind that this is in a crowded Bangalore Mediation Center. Your focus points, you get like an hour or two per case if you're lucky, and there's huge stress on the mediators. Despite that, this is the success rate, right?
Which is actually phenomenal, because for a court annex mediation program, a 65% settlement rate is a very high settlement rate for reasons cited by Purnima. These are not the most conducive states for settlement. There are, for settlement conversations, settlement talks. The mediators have a whole number of cases that they work with. It actually is reflective to me that we as a society actually do support processes where they are in control, where the parties are in control over the dispute, where they have an opportunity to sit across the table and talk about ways that they can resolve their disputes. So it's an indicator of this is a process that actually makes complete sense, and we need to create the ecosystem, the rules, and the support systems to make it far more effective process than it already is.
Interestingly, at the bottom of the slide, you'll see that the average time spent per case is only 146 minutes, which is, about 2 hours. Yeah. So, and if this has gone over a period of time, then, maybe you've had half an hour of mediation, then you come back and you have another half an hour of mediation. So the potential really there is much more. Yeah. These are statistics now before the various trial courts in Delhi, and we've just picked it up from the way that it's been made available to the public. You'll see that the first is the Tisari courts. The number of cases settled is 60.49%. This is a much shorter time period. Bear in mind, this is 2005 to 2018 December, so fairly up-to-date statistics. Yeah. So 60.49% have settled. About 40% not being settled, 39.51. The Rohini courts don't actually have a percentage, but the number of cases settled there is about 20,000, and not settled is about 12,500 approximately. Karkaduma, again, about 76%. Not being settled about 23%, right? So again, fairly high. And if you go to the next slide, you've got the Dwarka, Patiala, and the Saket courts. Again, Dwarka at about 71%, Saket at about 61%, and we don't have the percentage for Patiala House. But again, it's a positive state, and I can imagine that these would be places where you will actually not be having such an easy access to facilities, stress on administration as well as on infrastructure. In this context, so the question that we are now asking really is, private mediation, is this a credible alternative in this time and space? Having just concluded an employment law private mediation in Bombay last week, I just want to say that the focused time and effort of being in a room where parties have the autonomy to decide on the dispute is something that is exceptional. And parties are involved with their counsel. You get to hear not only about the dispute, but things that surround the dispute beyond the law. An arbitration or a litigative context is very focused on the law. In our employment matter, we actually did hear what was bothering the employee, issues around her, and which were revelations to the employer, who was our client. And they in turn had other issues to tell the employee in terms of, how and where she could go and what could happen. So these are questions that would not come up in we've just got a comment saying, you can't access the full screen on the data. We'll send that across through an email possibly and share that, or with links. But we'll continue at this moment. The focused time and expert of an employment law expert that we benefited from, it didn't settle, but I think parties really understood where they were coming from much more sympathetically, which wouldn't have happened in a litigative context. We also understand that it's a flexible procedure. The process is confidential, and quick resolutions, the ones that I have actually successfully been involved in, have all not taken more than 14 hours over a period of 2 days. Very intensive, but well, it's behind us in 14 hours.
Yeah. I mean, I probably would not use the word alternative for private mediation as much as an added requirement to our ecosystem. It is an essential, private mediation is an essential pathway that must be created for the mediation system as a whole to be able to achieve the results that it could potentially achieve, especially for commercial disputes. And that's what we're saying. The ability for the private mediation process to convene, which is to be able to work extensively with the parties before they come into mediation, to be able to work with the lawyers, with the parties, understand what the dispute is about, what are the gaps, what are the barriers that are presented in this dispute, informational, valuations, who are the right people who need to be part of this negotiation. I mean, essentially, if you view a dispute as a failed negotiation, there was a disagreement that came about, parties attempted to negotiate, that negotiation failed. Now they're coming into mediation for a facilitated negotiation. How can we create this negotiation? How can we set it up so that this time round it is going to be a successful negotiation with a neutral third party assisting this negotiation process? So in private mediation, especially for complex commercial disputes, the mediator has the opportunity to work with the parties and the counsel to be able to design the process so that when the parties come in, it can be a quick process. It can be a quick, cost-effective process. Added to that is the fact that this process allows the input of experts, the input of the various other players who otherwise would not have been part of the process. So in litigation, it is essentially the lawyer who represents it from the legal standpoint. In mediation, for example, the employment law dispute that we did in our office, it was about a termination, unlawful termination. The ability of the mediator to design the process such that the employee was able to have those conversations with the employer, with the project manager, be able to say, I don't understand what the reasons were for termination. You had an issue with me, you gave me 15 minutes to be able to defend myself. That was not a fair hearing that I had. The mediator was able to create an environment where that was possible. Could not understand the termination package. I don't understand why I'm getting X as opposed to Y. The payroll experts were brought into the mediation to be able to give an explanation. So the process was designed such that come in at 10 a.m., you're out at 4 p.m. or 6 p.m. with all this information sorted. The mediation, the fact that mediation took place was confidential because the employer was very keen that a precedent not be set. So the fact that the mediation took place, what the settlement terms, of course, were confidential. So the entire process was tailor-made to the parties, giving them the experience that commercial clients do expect in a mediation. And that essentially has been our focus. And as I mentioned earlier on, the CAMP experience in private mediation has been seeing the growth of the kinds of disputes, the value of disputes that have been coming into mediation.
So we're quickly moving on to the legislative framework with mediation that we've now see in commercial laws in India. When Section 442 of the new Companies Act, no longer new, of the 2013 Act came into play, we were very excited, and I know a lot of my partners and I wanted to be on that list, and we got on that list. Interestingly, training in mediation was not mandatory to be on that list. So, we were worried, but, a lot of us were on that list. It has been disappointing that the Company Law Tribunal has not been looking to mediation as a way to resolve disputes under the Companies Law. While the lists are being maintained by every registrar, we have not seen any active calling of mediators. In fact, there is always obviously an informal suggestions to settle a company law dispute, as with any tribunal asking parties before it. But there is no formal invocation of the mediation mechanism, which is a statutory provision. And that's a big failure, don't you think? Why has that not happened?
It's a good question. I mean, I'm not quite sure why it has not happened, but the fact is there is access to something like this. And as a conversation like this, when we're speaking to people who are interested in the process, the call out is, when you are representing, if you have a matter before the NCLT, to be able to ask for mediation with a trained mediator. So when the tribunal members say go settle, say settlement with a neutral third party part of it. We're still so early in the game, right? Commercial mediation is still such a new concept for our legal system, and it is going to take its time. From a legislative standpoint, there's a lot more that could be done to be able to structure these legislations in a way that they could be made more effective. But we have to look at the fact that these kind of legislations are coming out, and that is a big plus it's a step forward for sure. So I think as a community, we as lawyers, we as disputing parties need to be able to access or make use of the kind of legislations that are out there, to be able to say, I want to access mediation using the NCLT mediation panel. There are some good mediators that are out there. We need to up our game on having a good panel of of mediators trained in commercial mediation. So a lot more has to be done, but let's not miss the fact that we are taking those baby steps forward. Even, for example, the Commercial Courts Amendment, the 2018 amendment, it's a big step, and actually in conformity with how other jurisdictions are dealing with commercial mediations. A lot more needs to be done with respect to being able to formulate it such that these can be made effective. But the fact is, the spirit of the legislation is to be pushing commercial parties or commercial disputes to try mediation first before they access the court. They've reduced the monetary classification of what constitutes a commercial dispute from 1 crore to 3 lakhs. They have,
which is pretty much everything under the sun now.
Yeah, I mean, that
really an employment dispute is really a commercial dispute.
Yeah, so that really expands the scope for what qualifies a commercial dispute. And added to that, there is the amendment that provides for that, or that mandates in courts parties to try mediation before they can file suit unless an interim relief is sought. The spirit is right. The spirit is great. And, this is basically in model with the Italian example, where they mandated commercial mediation for a certain category of commercial disputes. 10% of commercial disputes come under the subject head of commercial mediation. And the Italian model has seen huge successes. 200,000 mediations that were conducted, just under 10% of commercial disputes that were mandated under this mandatory mediation requirement. 50% of those go into, and what is a mandatory mediation? What does mandatory mediation mean? It essentially means that you and your lawyer, the disputing parties and their lawyer, have to have a mediation session with the mediator, and then you either opt in to stay in mediation or you opt out to file suit in the court. And under this opt-in provision, 50% of those that came under this framework of mandatory mediation, 50% of them opted in for mediation, and a large percentage of them settled. For the first time in EU history, you're talking about a dip in the number of court filings under these commercial disputes that qualified under mandatory mediation. Now, we're trying to go that way. A lot needs to be done so that we do go that way. But as a service provider, I am encouraged by the way that we're going. I'm disheartened on how we do it, but at least the what is happening. The question is the how. And of course, you know, there's the Consumer Protection Bill, which is still pending in Parliament, but that has Chapter 5, which again provides access to consumer disputants to be able to access mediation. So yeah, Purnima, I really do think that legislatively we are trying. That's one part of the process, but many more that needs to be set in place so that this is a ball that rolls well.
I mean, just in the commercial courts, I think in Bangalore we've not even had great implementation of the act, even beyond mediation. So you know, it's unfortunately not become whatever else, but
yeah, and I think
the court is overwhelmed. There are a large number of cases.
They have to process it. They don't have a strong enough panel of commercial mediators. There is no sanction for parties who don't respond to a commercial to a notice to go into mediation. So these are, the interim relief is a sanctuary, an easy way out to be able to circumvent this requirement. So yeah, there's a lot more that needs to be done to iron out these issues.
So the next important, more positive thing that we're going to talk about really is cross-border mediation. There was a 2002 model law of the UNCITRAL, which talks about international mediation and settlement. After much discussion and lobbying, the word conciliation was consensually changed to mediation because that's what brought in what was happening in a number of countries. This is expected to be signed and open for signature in Singapore in August 2019, and therefore this will popularly be known as the Singapore Mediation Convention. For those of us who are arbitration lawyers, this is touted to be the next New York Convention equivalent. If enough countries sign up to this Singapore Convention, we will then have a situation where a mediated settlement in one country will then be enforceable in another country, provided there are enough signatories. And this then becomes a big boost to mediation across countries. There's a specific focus on commercial disputes. There's a focus that these be mediated and they be written down, and therefore will give enforcement, really then moving away from a judgment or a decree that has so much difficulty being enforced. This may also have a way out if people don't want to arbitrate and then want to mediate, and then there's easier enforceability through mediation. So it's a watch this space, but everybody's quite positive about it, and about 85 countries have already participated in the discussions with UNCITRAL, including India. So we'll see how that really pans out.
Yeah, I mean, I think this is a huge push for mediation when we finally have, one of the big concerns, at least in our context, has been what's the law on mediation. And I think this is going to be a big feather in the cap for mediation when we have an international convention that validates the process, that validates cross-border mediation, where and hopefully we'll be able to do for mediation what the New York Convention did for arbitration. And I think it's also indicative of the fact that there's almost a hunger in the space for dispute resolution, where increasingly parties are seeing the futility of not having options when it comes to dispute resolution. Why does it only have to be the adversarial process? Why shouldn't parties also have the option to be able to use a collaborative process that has the same sanctity in law than as the adversarial process has? So the Singapore Convention is definitely going to be a push for mediation. We hope India will be a signatory. India being a signatory will mean that we will have to have more laws on mediation that give more validity to the mediated settlement agreement, that we don't have to go right now on the private mediation. We basically have to piggyback on to conciliation. So we follow the mediation process, but invoke Section 74 of the Arbitration and Conciliation Act and have it as a conciliated settlement agreement. When we're able to have recognition for mediation as the settlement agreement under mediation law, I think that will be huge for mediation as well.
Excellent. So the last slide that we really want to then is if you want to put into your clauses, whether you're practicing lawyers or in-house counsel or somebody who's interested in mediation, you know, how do you structure a dispute resolution clause? You know, what has become popular really is a tiered dispute resolution clause where you could actually have a negotiate, arbitrate sort of clause. Now, if you introduce mediation in this, then it becomes a negotiate, mediate, then arbitrate or litigate, depending on the nature of the dispute that is really there. I know the Singapore folks, the institution and the Singapore government has really been pushing the ArBMed clause. Could you talk a little bit about that experience and see if it's really working, and does it need the backing of an arbitration clause?
Yeah, so basically this is something that SIMC, that's the Singapore International Mediation Center, is promoting with SIAC, where the contract actually reads, the dispute resolution clause reads as an ArBMed protocol, where the dispute goes into SIAC as an arbitration, the tribunal is constituted, the issues are framed, and then it goes out into mediation with SIMC, a completely different institution. Whatever gets mediated, most often it is the entire dispute that does get mediated. Then it goes back into arbitration and it's passed as an arbitral award. If there is any issue that's not settled in arbitration, in mediation, then it goes back into arbitration with SIAC, and it comes out as an arbitral award.
So you could have some parts being mediated and some parts being arbitrated.
Exactly. So the advantage is, for those who, from the mediation perspective, there is that concern, if this doesn't settle in mediation, then what happens?
Right.
Under a protocol like this, you know that it will be arbitrated if it's not settled in mediation. For arbitration, it actually significantly reduces the time and money spent on an arbitration, because large parts of the dispute is mediated. And mediation is a much quicker process than arbitration is. The average time frame for a mediation, from our experience, is between 1 to 3 sessions. The success rate for mediation is extremely high. 80%, 85% of disputes that go into mediation settle in mediation. So the ArBMed protocol is essentially a win-win for the skeptics and the supporters, and something that's being promoted. We're looking to see how we could do the ArBMed protocol as well at our center, beginning to do it, but that's definitely options that will be available to the dispute resolution community in the near future. But this is a critical aspect of being able to access these processes, when your dispute resolution clause sends you into mediation. And as a lawyer, you perhaps have seen that. When you propose mediation to a client that does not have a contract that reads mediation, that is so much more challenging as compared to when your contract sends you out into mediation.
Right. I was also thinking that if the Singapore Convention really gathers enough momentum, you don't really have to come back to arbitration to enforce your award, as it were. The Singapore Convention will then allow you to enforce your mediated settlement in the context of international dispute, or a mediated settlement in the context of international. So these clauses on how you structure them could also change in the coming year.
Absolutely.
And how they
no, but the Aab Med Aab also is to be able to address the concerns that a party might have of if mediation fails, then what?
Right.
But with a protocol like this, you do know that you don't have to start from scratch all over again. You can mediate whatever, and the rest, how many of issues that get settled in mediation is in mediation, and the rest goes out in arbitration.
Would you have the same panel? Personally, I would think you'd have a different mediator and a different arbitrator. So just for the benefit of the audience, could you sort of talk us through?
It would be in an Aab Med Aab kind of protocol, or in a Med Aab kind of a protocol. It would be important that the neutral for mediation and the neutral for arbitration are different, because just because of the philosophy of the two processes. Mediation is the confidential process. Mediation is a process that allows and encourages the parties to be able to explore their underlying interest, to be able to engage in a constructive negotiation, and the ability of the parties to be able to be fully engaged in a mediation would be compromised if the parties felt that that same neutral will then be on the adjudicating table passing judgment against them, which is why it's very important that the mediator and the arbitrator are two separate neutrals.
I was just reading the convention, and Article 13 specifically says that the mediator shall not act as an arbitrator in the context of a dispute, which is the subject matter of the mediation proceedings, and then if it goes to arbitration. So clearly that is a well-recognized division.
Yes.
Where we just wanted to end by saying that the following types or categories are well suited to mediation, and there is a little bit of a myth to say that mediation is really suited for family law. Personally speaking, I've had a great experience with mediation in commercial law, which is the bulk of the kind of disputes that we do at Samvad. We've seen employment law, we've seen joint venture agreements, we've even seen situations where there are corporate disputes between warring shareholders, and we've had success in resolving them through private mediation. Whereas obviously we've had some success with the court annex mediation program as well, but I really can't compare the two because the quality and the infrastructure is very different. Do you want to specifically have any reference? I was also talking to one of my other partners on the IBC. Aparna has been involved in the IBC process in detail. The IBC doesn't really have any reference to mediation. Whereas an operational creditor is often encouraged to settle because people are looking at it as a recovery mechanism, although that's not what is meant to be. Similarly, what people used to do in the context of winding up petitions under the 1956 Companies Act. But again, if the NCLT would look to mediation and go through the list of existing panels of mediation, that could be some way to look at a way. Srinivas, I think you have a question. Do you want to ask us, and we'll see if the audio works? Or you can type also. Srinivas, I think if you can type your question, we'll pick it up. If you can't, we can't hear you. We know you have a question, but we can't. We're seeing a few other questions as well. We'll take them up at the very end. Tara, did you want to talk about any more collaboration on the mediation, collaborative dispute resolution before we take questions?
Yeah, no, I think the importance of learning more about the process as lawyers, especially to be able to engage more effectively in understanding what is mediation, in dispelling the stereotypes that mediation is not for commercial disputes, that is only for small claim, matrimonial disputes. It is important that we all learn more about mediation. In a recent survey that was done, one of the reasons that lawyers, this is the Global Found Conference, a survey on dispute resolution that was done all around the world in 2016, I think in 40 odd countries. A question that was posed to the lawyer community. This convention brought in all the various stakeholders of the dispute resolution landscape. And when posed, the question that was posed to lawyers was, how do you choose the process that you recommend for your client? The overwhelming answer was familiarity.
Right.
Familiarity is what drives you to suggest arbitration, litigation, or mediation to your client. And I think we owe it to our clients to be able to propose the right tool for the right matter. And the only way we can do that is by learning and understanding more about the different resolution process, different dispute resolution processes out there. If all we know, if all you have is a hammer, then everything looks like a nail. If all we know is adversarial, if all we know is a litigious process, then all our cases are going to go to the courts, and we're going to have our 30 million cases pending. But there are other processes out there, and we have to start seeing ourselves as dispute resolvers and using the multiple forums that are out there to be able to strategize of filing to be able to get this interim relief, proposing mediation at the right time, using arbitration, so to be able to build our skill set. And we as a center work very hard in trying to create that awareness. We hold training programs on how to be effective in a mediation, B, how to negotiate, keeping in mind the interests of your parties. How do you engage in effective interest-based negotiations? There are so many training programs out there. Please go up, sign up, learn more. We have an upcoming one in February 16th on advocacy in mediation. What does it take to be a good mediator in mediation? Very different from being a good lawyer in court. But what does it take to be a good lawyer in mediation? And when lawyers come into mediation, knowing that it's a very different process from court, they support the process so much more effectively, and we're able to support our clients into hitting those 85%, 90% settlement rates within a day or two.
Interestingly, Section 89 of the CPC effectively confers the judge with the ability to screen for, arbitration, conciliation, mediation, judicial settlement through Lok Adalat. I mean, there is some application of mind that happens at that very initial stage. It should happen.
Yes.
Which would then guide persons to go to the right forum. And what you're effectively saying is, counsel should also exercise that actively when somebody approaches them.
Exactly.
Before going down the regular route to knock on our doors.
I like that analogy. Absolutely.
Yeah. So we are now taking questions. I think for those who didn't get the full screen data, we will try and get that to you. Thank you for your comment. There is a question which says that in Telangana, the mediation has not been very effective and people are not aware of mediation. There is also a problem of pre-litigation mediation awards. What changes of policy on civil commercial mediation settlement award can be made compulsory and enforced? And what is the constitutional validity of us trying to enforce mediation? So I think there are a number of issues that are being raised over there. Mediation continues to be a voluntary process. It can only work if parties buy in and want to mediate. It is not a forced process. So we can't have really compulsory mediation. We can encourage parties to mediate. Courts can encourage them to go to mediation, but you can't really say, please sign on this dotted line. So that's the idea that needs to go across.
Yeah, but when we talk about compulsory mediation or mandatory mediation, what does that mean? You're absolutely right that mediation is a voluntary process. So mandatory mediation would essentially mean you are mandated to one session of mediation.
Or give it a try.
You have to try mediation. You're not mandated to settle at mediation, but you're mandated to try mediation. But because it's a voluntary process, you can opt out of the process at any point of time.
Okay.
And our commercial courts amendment is hoping to kind of endorse that spirit of mediation.
So the enforcement in India of settlement awards really is through the Arbitration and Conciliation Act. If you look at the act that provides that, else it becomes another contract which parties have then signed.
Yeah.
If you go through the court annex procedure, the courts then take it upon themselves to sort of confer a decree based on what has been mediated. So there are different ways of enforcement depending on where you've gone. You know, if it's court annex mediation, there is an additional punch because it becomes a decree. Otherwise, we use the Arbitration and Conciliation Act.
And a point to add to that, to the fact of enforcement, is that remember that this is a process of self-determination.
Yeah.
The parties themselves are the ones who arrive at the settlement. And therefore, very rarely, very, very rarely do you need to enforce a settlement agreement. So unlike arbitration and litigation, where it's a neutral third party who tells the parties what to do, where one wins and the other loses, enforcement becomes a huge issue. In a process like this of self-determination, enforcement is not an issue. But that said, you're right, if you're in court, it goes back, the judge passes a final non-appealable decree. If it is in private mediation, we go under the Arbitration and Conciliation Act and pass it as a conciliator settlement agreement.
Thank you. We will share the PPD with participants, so that's a recurring theme. There's been a question on what should in-house counsel first do when there's a dispute raised by the other party, and if they've gone to court and got a stay. Now, obviously, it depends on what that stay is and whether you want to have that stay vacated. I want to say that mediation can be invoked at any stage of the dispute, right? So it does not necessarily have to be something that is invoked prior to going to court. We've had a situation where one party went to court and tried to use that as a way of, you know, coercing people to continue to be in court. But even while matter is in court, you can still go to mediation. So it really is whenever parties wish to go to mediation. There is also a situation where even with a stay, you can continue to mediate. There's nothing that's coming in your way. So the first question really is, if it's a commercial document, you have mediation as a prior dispute resolution clause within your agreement, and it would better to have that so that, you know, it sort of gives you the first thing of, you know, they didn't mediate and they've gone off to court.
Exactly.
But obviously it depends on the exigencies of the situation and what kind of facts that go with that. So the point really is mediation can happen at any point, of the dispute, and sometimes I've seen the same people who said no to mediation at the very beginning are willing to go for mediation after, you know, standing in the city civil court for 3 years. So exactly. It depends on where we are.
But that said, you know, research out of Singapore has shown that the best time to mediate is actually early on. The faster you get to mediation, the higher the chances that you are able to settle quickly, that you're able to settle, one, B, that you're able to settle quickly, and you're able to actually preserve that relationship and move on. So that's why, as Purnima mentioned, the importance of having that dispute resolution clause that will get you to mediation very, very early on. But that said, you can mediate at any point. We are dealing with matters right now at our center where the matters have been in court for 7, 8, 10 years. So you can mediate any time during the life cycle of the dispute.
So how would you initiate? There's a question, and what would be the communication with the other party? I mean, I just say that if anybody comes to me with a dispute, and if people are open to mediation, it is not, as was told to me early on, that it's not a lack of strength. It really is does not mean that your case is weak, but please do feel free to call counsel on the other side if you don't want to put it in writing. Communication between the parties can be that, you know, you want to explore mediation as a possibility. People are increasingly open to the idea and they will come back. You could obviously word it in language to say it's not prejudicial to your rights in any manner. You continue to work on the substantive aspects of your case to strengthen whatever advice that you would give. But this is something that you could still communicate.
Just to add to that, and it's a very, very good point. When again, we as lawyers, when we send out that legal notice, to be able to draft the legal notice in a way that invites the other party to mediation. So the language that we use has to be open, inviting them into a collaborative dispute resolution process, whilst at the same time being able to hold on to the fact that I do have other options that are available, which could be going to court. But when we talk about mediation as an option, as part of your toolkit, be mindful as lawyers how you communicate to the other side. Are you communicating in a manner that is going to alienate your client and alienate the other side and drive him or her straight to court? Or are you able to communicate in a way that you are able to invite them into mediation, while at the same time keeping your options fully open to be able to take this up in court if you need to take it in court? So communication is a very important aspect of how you do it.
We have another question on, what should go into your mediation clause. What really is going to go into your mediation clause? Remember, this is tiered dispute resolution. So you can suggest that parties will try and negotiate between specific individuals. If parties at the time of entering into a contract already know, say they want to mediate at CAMP, or they want to mediate at the Singapore Institute of Arbitrators, and the country now has a number of interesting mediation options. If you want to choose one of them, then that could be specified there. I would think it's important to put a timeline so that, yes, we will try and mediate within 2 weeks of receipt of a legal notice, and mediation will automatically be triggered. If you want to say that if any interim relief will only be obtained after you complete your mediation, you can have that language in. A number of mediation institutions, I know that CAMP also has a model mediation clause. You can have a look at that, but that's really where things are. In terms of, there was a question, Tara, on the Consumer Bill of 2018, the Consumer Courts Bill of 2018. Do you want to take a shot at that?
The question
is, could you share your opinion on the mediation provisions of the Consumer Protection Bill 2018? Will the procedure provided by the bill be sufficient to ensure that the success of mediation in consumer disputes?
I don't believe chapter 5 of the Consumer Protection Bill essentially gives option to parties to be able to access mediation. So again, where there is a panel of mediators that are available, so disputes that come under the consumer courts can have access to mediations. I have not seen the rules and the procedures. It's still in the Rajya Sabha, so I guess it has to go through that approval process before the procedures are laid out. Again, maybe I haven't got it fully right, but I'm not aware of the procedures that have been laid out for how mediation under the Consumer Protection Bill would be would play out.
There are questions on online dispute resolution, and so online dispute resolution is a whole new bucket. You can have online arbitration, you can have online mediation, and I know that there are online service providers on that. I personally haven't done anything online, so I won't be able to comment on that. I would still prefer in-person mediation. I don't know whether you've had any.
But you know what? I think again, especially when you're talking about consumer disputes, when you're talking about small claim disputes, large volume, small ticket kind of disputes, there is a big space for online dispute resolution, and it is the way dispute resolution is going. It's a matter of time before it happens in our context as well. But I am more focused right now. I kind of agree with Purnima in that we have to make mediation familiar, known, part of our legal system before we can take that next big step on doing it online. But there's definitely a huge space for online dispute resolution.
There's a question on what kind of employment cases can be covered. I think the whole range of employment cases can be covered. So I don't really see any limitation on that. I mean, even if you look at the Sexual Harassment Act, it has a provision for conciliation, which is sort of the byword for mediation as well. But of course, that is a separate legislation and there's a separate process that needs to be followed. But other than that, everything else really, I think, can be looked at through mediation. I don't see any limitation there.
Any kind of employment dispute
yeah.
could be mediated.
Yeah.
In fact, in other jurisdictions, employment disputes are huge in mediation.
Yes, I agree.
In the mediation space, sexual harassment probably leading that list. In the Indian context too, we have to find the space how mediation could be used more effectively in the sexual harassment domain. New legislation, a lot of stuff that still needs to be ironed out, but suffice to say, it's a great space for mediation.
Right, so I don't think we have any more questions left. Thank you very much. We've had a wonderful 1 hour talking about mediation. Both Tara's and my name are available on our respective websites with their email IDs. Should you need any additional information, please feel free to write to us. And thank you very much for attending this webinar.
Thank you, Purnima, for putting this together, and thank you for your participation. We look forward to more mediations happening.
Thank you. Bye.
Oh, that was an hour.